Good morning. Thank you for inviting me to join you today to discuss human rights violations in Morocco. Not only to discuss, but let's act. First, let me single out a Moroccan lawyer in your midst whose moral courage stands as a beacon to all of us. Abdessadek Bouchatawi was a leader among the fine Moroccan lawyers who defended the RIF protesters. The government prosecuted him for essentially conscientiously defending and representing his clients. After he was unjustly convicted and sentenced, he and his families were forced to flee Morocco to seek asylum abroad. A year ago, France granted him political asylum. Congratulations, Abdessadek Bouchatawi. I will briefly set the stage for this talk, and you have my apologies if I cover some ground that's already familiar to you. The people in the RIF region in 2016 and 2017 engaged in enormous protests against the government. They had a list of serious and chronic social and political grievances, which the government had for years ignored. The government overreacted with crackdowns which can only be described as brutal. Hundreds of protesters were arrested, detained, tried, convicted, and sentenced. Journalists who covered the protests as news events were also prosecuted. The government really brought its criminal justice system to bear on about 43 key defendants. This group included Nasser Zefzafi, who the government identified as the alleged ringleader. Among the 43 was the well-known journalist and critic of the government, Hamid al-Mahdawi. All 43 were convicted in 2018 on a wide variety of overlapping criminal charges: sedition, unauthorized group gatherings, separatism, armed insurgency, and inciting violent assaults against the security forces. The trial judges imposed sentences of up to 20 years in prison. The Court of Appeal in Casablanca conducted hearings in February, March, and April last year. Our non-profit association of pro bono lawyers, International Senior Lawyers Project, sent 4 lawyers to observe 3 hearings in March and April. One of those volunteers isn't here today, Huda Hawami of the Tunisian Bar. She will speak to you later today. My colleague and I attended a hearing in mid-March. He's a judge fluent in Arabic and English, and he sat next to me at the hearing. We then published a 10-page final report of trial observers. The 6 judges on the Court of Appeal unanimously upheld all the convictions and all the sentences. Prior to the hearings, there were published reports that both were widespread and credible that the police had routinely tortured defendants. Amnesty International reported that the police or prison guards had beaten, suffocated, stripped, and threatened to rape numerous of the protesters. In July 2017, the Minister of Justice in Morocco announced that he would investigate into at least 66 cases of suspected torture by police. In the Court of Appeals, the public prosecutor attempted to rebut or at least challenge these multiple charges in his closing arguments. He referred specifically to Nasser Zefzafi, the prosecution's chief target. With a straight face, the prosecutor said that the prosecution had asked Zefzafi whether the police had used any violence against him. According to the prosecution, Zefzafi said no. Let me ask you, do you believe this? Not only were these defendants tortured, but the courts admitted into evidence and considered the statements that they had made under torture. Amnesty International also reported that at the trial, the judges refused to receive or read or hear the testimony of more than 50 witnesses for the defense. To justify excluding these testimonies, the judges gave no adequate response. I observed the presiding judge of this appeals court summon and confront individually about 6 defendants, each for about 20 minutes. A defense lawyer stood silently behind each defendant during this hostile interrogation by the presiding judge. In his loud and angry voice, accompanied by vigorous gestures, the presiding judge shouted his questions and accusations. One female defense lawyer had the temerity to speak up for her client. The presiding judge cut her off and directed her to remain silent while he continued his tirade. 2 of the defendants facing these attacks were bold enough to say, "I'm a defendant, not a witness." Now, I have worked in courts in Europe, Asia, Africa, and the various states of the United States for the last 58 years. Never before in those 58 years have I witnessed such behavior by a judge. For about 2 hours, I witnessed the journalist Hamid al-Mahdawi speak to the panel of judges. Let me tell you what I saw and heard. He was unkempt. While speaking, he walked around the well of the court below the judges. He spoke in a loud voice. He read extensively from his legal papers and cited court cases. He repeated himself. He repeatedly interrupted the presiding judge. He repeated that he was innocent. He said he knew none of the defendants. I learned later that he lived near Rabat and only traveled to the Rif region in the north to cover the protests. This was an unforgettable and disturbing display by the defendant. My fellow ISLPA lawyer and I was sitting in the court on the same bench as Hamid's sister and his wife, Bushra Konchaki. Speaking in Arabic, my colleague asked the 2 women to explain Hamid's behavior. His wife said, quote, "He is a calm person in general, but the fear and psychological pressure and his stay in jail made a change in his behavior to a different and agitated person," close quote. That was an understatement. I inquired later and learned that the authorities had imprisoned Hamid al-Mahdawi in solitary confinement for 470 days before trial. Imagine this, a nationally known journalist facing no charges involving violence, held in solitary confinement for 470 days. That bombshell explained everything. In that courtroom, for 2 hours, I saw and heard a broken man. There's a word for that. It's torture. Torture can break a man, and it did. Our organization, International Senior Lawyers Project, wrote an amicus curiae brief, a friend of the court brief, which we submitted to the Court of Cassation in Rabat. As a friend of the court, we cited cases from the European Court of Human Rights, which condemned extended terms of solitary confinement. We cited a key case where the Grand Chamber of the European Court said this about prolonged solitary confinement, quote, "Complete sensory isolation coupled with social isolation can destroy the personality and constitutes a form of inhuman treatment which cannot be justified by the requirements of security or any other reason," close quote. Another European court case involved a defendant held in solitary for about 390 days. The court held that these conditions could cause the defendant, quote, "both mental and physical suffering and feelings of profound violation of his human dignity," close quote. In these and other cases, the European Court of Human Rights found in favor of the confined defendants and against the governments which had tortured them. The court awarded modest damages to these victims of official torture. To bring you up to date, The Court of Cassation in Rabat has not yet acted on the appeals of the protesters and the journalists. We found two international human rights treaties that Morocco has ratified. One is the International Covenant on Civil and Political Rights, the ICCPR. The other is the Convention Against Torture. Both treaties apply to these cases. In the CCPR, Article 14 requires governments to issue or ensure, quote, a fair hearing by an competent, independent, and impartial tribunal, close quote. The government must assure that a defendant has the right to obtain, quote, the attendance of an examination of witnesses on his behalf. The ICCPR prohibits governments from coercing confessions. A defendant may not be, quote, compelled to testify against himself or to admit guilt. Article 7 of the ICCPR bars governments from subjecting defendants to, quote, torture or to cruel, inhuman, or degrading treatment or punishment. Morocco ratified its obligations to comply with these obligations. Do you have any doubt that Morocco violated its obligations under both the fair trial and the torture articles of the ICCPR? Similarly, Morocco ratified the Convention Against Torture. Morocco ratified an absolute prohibition against torture and is barred from invoking any, quote, exceptional circumstances to justify torture, close quote. Article 15 of the Convention Against Torture bars Morocco and its courts from considering any statement that was made under torture. Again, do you have any doubts that Morocco violated its obligations under the Convention Against Torture? It is fair to say that neither the ICCPR nor the Convention of Torture can boast of enforcement machinery that is robust and effective. Just the opposite. There exists in Africa, however, a far more robust and effective human rights treaty and enforcement machinery. This is very significant. The treaty is the African Charter on Human and People's Rights, and the enforcement machinery is the African Commission on Human and People's Rights and the African Court of Human and People's Rights, based in Arusha, Tanzania. Now, there are 55 countries in the African continent. 54 of those 55 have ratified the African Charter on Human Rights. All those 54 countries have subjected themselves to the jurisdiction of the African Court on Human and People's Rights. Only Morocco is the exception. Only Morocco is the outlier. Only Morocco has failed to ratify the Human Rights Charter. Only Morocco avoids the oversight and jurisdiction of the judges on the African Court of Human and People's Rights. Now, if Morocco does ratify this Continental Human Rights Charter, it will subject Morocco and its courts to the jurisdiction of the African Court of Human Rights and People's Rights. So that would mean for the first time, Morocco's monarchs, judges, police, prison guards, and politicians would have to answer to their fellow African leaders when they abuse human rights. African judges would adjudicate whether Morocco violated its human rights obligations. So if the judges could impose sanctions to public violations of human rights in Morocco, perhaps this would hopefully modify the behavior of the government toward its fellow citizens. One of the recurring themes at the hearing was the government's claim that this was a purely criminal trial and that politics had nothing to do with it. For instance, one of the defendants testified that he joined the protests as a result of the deteriorating social situation in the Rif region. The presiding judge cut him off. He interrupted him. He warned the defendant vaguely worded laws, reliance on illegally obtained evidence, defense counsel in fear of arrest, a presiding judge's language and demeanor devoid of any semblance of impartiality, and the foreordained outcome, all accomplished while maintaining a facade of conventional institutional normality. These are my concluding words that we published in our final report of trial service.
Thank you very much, Mr. Richard.
If you were to ask me,
What?
There's like 2 more minutes.
2 more minutes.
Yeah, on the video.
On the video, okay. Sorry.
what is to be done? I would offer the following ideas. First, attempt to file an amicus curiae brief, a friend of the court brief, written by experts supporting the defendants in the Court of Cassation in Rabat. Second, urge the government of Morocco to sign and ratify the African Charter of Human and People's Rights. Third, permit the African Court of Human and People's Rights to consider and adjudicate the appeals of the 43 defendants who would claim that Morocco committed multiple violations of the African Human Rights Charter. Fourth, submit a petition to the UN Special Rapporteur, Niels Melzer, that he should investigate the torture of not only the 43 protesters, but all protesters. Finally, let us all recognize and applaud the courageous work of the Moroccan lawyers defending their protesters